If a revocable living trust is such a good idea, then why would anybody ever recommend a will? Remember, I said that a will means there likely will be a probate, the process I described earlier. Why would you ever want to go the more formal route than just having the successor trustee carry out the terms of your revocable living trust? Well, one of the reasons for that is the successor trustee after your death of a revocable living trust, they don't get any legal help because they don't know that they have to, or they don't want to pay the legal fees. And so guess what? They don't carry out the terms of your trust. Nothing happens. Or maybe something happens, but it's not exactly what should have happened. And nobody else understands how the trust is going. Maybe the situation is 2 of the 3 kids should inherit, but there's nothing done. Maybe just the successor trustee takes and manages it. Maybe they don't. What I'm saying is that, and even if it's not ill intent, people just don't know what they don't know, so they don't do things correctly. Let me explain a scenario where we often see a revocable living trust not being correctly administered after a death, and that has to do with a couple. So with us, spouses, especially in Washington and Idaho, it's community property. And on one person's death, they don't know and they don't do anything. And it's just like the revocable living trust was before the person died. But typically in a revocable living trust, when a decedent dies, their share, their half of the estate, is supposed to go into an irrevocable trust with a new tax ID number. And that irrevocable trust can be for the benefit of the surviving spouse, and the surviving spouse can manage it. But oftentimes the surviving spouse is not to redirect those assets elsewhere, like to a new spouse. Instead, the assets in that irrevocable trust are supposed to go, for example, to the kids of that marriage, the decedent and the surviving spouse's marriage. But because the trust was never set up, there is the possibility of a disinheritance of those kids because the spouse just does a new estate plan with the new spouse and everything goes to the new spouse or the new spouse's family. You might have heard of such a situation because it happens. Another reason beyond disinheritance that a revocable living trust might not be a good idea is maybe it's a taxable estate. Maybe this couple had $4 million. So their revocable living trust is set up that on the first death, that this irrevocable trust is set up. And it's not just to avoid disinheritance of the kids, but it's to capture the credit exclusion amount of the first spouse to die. So if we have a $4 million estate, $2 million, half the decedent's share, is supposed to go into this trust. That means that when the surviving spouse dies, their estate doesn't pay taxes on that $2 million because that $2 million was exempt because it went into this tax exempt trust. Instead, the surviving spouse, their $2 million passes under Washington's laws tax-free because it's only their $2 million. But what happens again is that the surviving spouse didn't set up the trust properly. Instead, rather than the $2 million passing of the deceased spouse going tax-free and the $2 million of the surviving going tax-free, instead what happened is surviving spouse has $4 million. What does that mean? That means that's above Washington's credit exclusion amount for estate taxes, and there is going to be an estate tax of at least $200,000 plus on that because they didn't do it right. So they paid $200,000 in unnecessary taxes because they didn't understand their trust. They didn't talk to a lawyer who, for a very small amount of legal advice and fees, would have made sure that they avoided a $200,000 estate tax. That's one of the reasons that revocable living trusts, while they sound like a really good idea, in practice don't work well.